This is the third series of our fundamental human rights enshrined under the Constitution of Uganda of 1995. So, we want to know which kind of fundamental rights that can be taken as derogable or non-derogable right. Let's dive and see. Now, let's dive and see Article 29 of the same Constitution. Article 29, it portrays the protection of freedom of conscience, expression, movement, religion, assembly, and association. So, in this same way, the Constitution is giving you a right to freedom of speech and expression, which means you have the freedom to speak out whatever you want, to speak out your mind, to speak in any media. As you can see, I'm using, this is media, I'm speaking, I'm having everything, I'm speaking via this platform. But remember, there are some regulations, the laws that protect, or the laws that governs the media, which means this is a derogable right. Sometimes when I violate the law, the right can be taken from me. Now, again, the Constitution says under 29 clause 2, it says every Ugandan shall have the right. The word is shall, meaning it is a mandate. He must have that right to move freely throughout Uganda and to reside and settle in any part of Uganda. That's why you see, if you feel like you want to go in any other district, you can go there, you can make a business, you can go there, you can settle, you can go there, you can buy land in any other part of this country. So the Constitution is giving you that mandate to travel within the country. It is a freedom that you can enter into an association. It is a freedom that you can enter into any religion you wish. The Constitution gives you the mandate that you can buy land, you can make any business in any part of Uganda that you want. But I've said that there are some regulations that governs businesses, that governs associations, companies. So however much you're given the freedom and the right to exercise, but again, they are regulated. That's why we are saying that they can be deprived, they can be taken away from you. Let's dive and see Article 30 of the Constitution, the right to education. Every person in Uganda owns a right to education, which means you can go to the school, any institution, any university, and you get that education. But some instances, even the education can be limited. Article 31, it gives the right to family, that a man and a woman are entitled to marry only if they are of the age 18 and above. Now, the right is to form a family, to marry. You are to marry at any time, whether today or tomorrow. You are to marry. But the article, subsection 1, it says that you must be 18 and over, which means a child who is 16 cannot enter into marriage. That is what we call voidable, and it is valid in its format. So, marriage between persons of the same sex is also prohibited. Now, it means that you can enter into marriage, but you must be of different sex, a man and a woman. So, let's dive into and see Article 34, the right of a child, rights of children. It is also governed by the Children's Act, where it always talk about the well-being, the welfare of a child, that a child must be catered for. He or she must be given that care, the love and care by the parent. That's why we always say that it is the welfare, the right to education, treatment. The child is entitled to have those interests from the parent, from the guardian, or any person who adopts that child by the law. So when you look at subsection 5 of the Constitution under section 34, article 34, it says that for the purpose of the clause of the article, a child shall be that person who is the age of 16 years. But why they are separating this from the other law? They are telling us that a person who is eligible to enter into certain contracts, marriage, is that person who is 18. But again, that they are saying that the definition of a child under this act, under this constitution, is a person of 16. Now, why do I mean? To explain it more, you have to understand that a child of 16 can sometimes be allowed to enter into some contracts. That child can be given a mandate to bring his or her ideas in a family, to be listened, to speak out, to give ideas. But to some extent says they are limited. He or she cannot enter into uh, big contracts. He cannot enter into marriage because he's categorized as a non-adult. But again, they are saying that a child, once you are taken into a custody, then you are separated from adult offenders. And now the adult offenders are those who are 18 and over. So now let's look to another key right, key fundamental right, the right to access information. It is a mandate that you have a right to access information. Take an example. When the law is enacted by the parliament, they must gazette to the public so that every person in this country can access. That's why they gazette. And here, the law protects you. When you want to know any information about something, then you go under Article 41 of the Constitution. Now, Article 42 of Constitution, it talks about the right to just and fair treatment in administrative decisions. That any person appearing before any administrative office or body has a right to be treated just and fairly and shall have a right to apply. The word is shall, which means he or she must. It is a mandate. It is his or her discretion to apply to a court or any other administrative decision. So the article is explaining that once you want to be heard, once you have a problem and you're appearing any administrative office, it is a mandate. They must hear you, they must treat you fairly and just. They must, as the word must. Now, Article 46, it talks about the effects of laws enacted for a state of emergency. Now, what do I mean? Here, I mean that the parliament shall not enact any law that is bringing, that is making a controversy, that is contravening with the rights. I can give you the example that if a certain region is in the state of emergency, it means that some rights, take an example, a right to movement, speech, association. Sometimes when you are in a state of emergency, take an example, COVID-19 or recent, then the parliament will not come to intervene for the violation of a certain right, because the state, that state or that region is in a state of emergency. So there will not be enactment of a law that will bring or will support the freedoms of the same. So meaning when the state is under emergency, in simple terms, it means that some rights are taken off from you. Thank you for watching. Thank you for listening. We always urge you to subscribe. We always urge you to comment and share for more videos. Brighton Mtachache the barrister, I wish you well.